And one of the big things of the time was legislative corruption. I mean, there's no doubt about it.
Article 4, Section 6 specifically delineates the superior courts as having jurisdiction over all issues involving title and possession of land. I think that's one of the protections that's inherent in the Constitution.
That is.
This gentleman cannot get his issues heard. What's going on?
You know, yeah, I don't know. It's kind of sad. You know, the power of the court, and of course the power of the judge, to the extent it has power, comes from the court, recognizes in the American system of jurisprudence that you have to have subject matter jurisdiction to go forward. So we brought the issue of the subject matter jurisdiction to the attention of the court, and we called it a query of subject matter jurisdiction, and the court sort of ignored it, which, you know, I couldn't understand it. And we brought a motion for summary judgment forward, and the court said, well, it's too long. But it wasn't too long. The rule says that if it's over 24 pages, the court may not read it. This was 27. If the court didn't read the 3 pages, that would have been fine. So he just sent it back. So, trying to do what he wanted us to do, we sent in 2 motions, which are now on our webpage and anyone can read, explaining the court's subject matter jurisdiction and explaining the Constitution of Washington and explaining how due process works in Washington. And the court sent that back, citing a rule that says you can't submit 2 motions for summary judgment at the same time. So now we're rewriting it again. And we're trying...
And what are we doing right now, Counselor?
We're going to start out with explaining the constitutional provisions relating to the jurisdiction of the Superior Courts of Washington, which are somewhat unique because most constitutions don't designate all of their courts of record. Our Constitution set up a working judicial system.
Terrific, thank you. Now, Mr. Stafne has a number of pending questions in one of his cases with the federal court to certify to the state superior court involving the potentially unconstitutional Washington Deed of Trust Act. Now, he is having a difficult time being heard, as I was reading on his website recently, and I think we're going to talk about that right now. Mr. Stafne, what do you have for us?
Well, you know, Chris, it's good to see you again.
As always.
And I guess what I want to do is I want to start out explaining a little bit about why the Washington Constitution was enacted in the terms that it was. It was enacted in 1889. There were 75 framers. 23 of them were lawyers. And during this time period, 3 years prior, there had been a period of martial law. 30 years prior to that, there had been a period of martial law. The notion of a separation of powers hadn't worked out very well. And so the people of the territory of Washington were concerned because actually soldiers had come into their houses and removed them. And so you had a situation in which they'd watched as the governor battled with the courts, and one of the big things of the time was legislative corruption. I mean, there's no doubt about it. Our framers of the Washington Constitution were as concerned about the corporations abusing them as the government. Railroads were the big thing at that time, but so were banks. And Washington's Constitution, unlike most constitutions, actually has specific provisions designed to deal with the banks and to deal with the corporations. So, unlike most constitutions, the Washington Constitution specifically told the legislature how they were to handle policy issues regarding corporations and banks. And this is important because when you look at what our framers want to do, you have to understand the historical context. They were concerned about protecting people's homes, protecting people's properties. They were also concerned about protecting them from corporate interests and people other than the government. And the purpose of the separation of powers is to protect individual rights and individual property rights.
And I believe that's part of the reason, as I have read some of our Constitution and the relevant portion here, I see that the Article 4, Section 6 specifically delineates the superior courts as having jurisdiction over all issues involving title and possession of land. I think that's one of the protections that's inherent in the Constitution.
That is, and I think that as you look at any analysis of the Washington Constitution, especially when you're going to deal with the power of courts, you have to start with the jurisdiction. And so what Washington did was very unique. They created a superior court and gave it original jurisdiction that they intended that the legislature could not interfere with. It's sort of like when you look at the Due Process Clause. They adopted the Due Process Clause from the United States Constitution, exact language. But obviously they didn't expect it to mean the same thing because they wrote a strikingly different Washington Constitution. So the Due Process Clause of the federal government incorporates the federal Constitution and laws, and the Due Process Clause of Washington's Constitution was intended by the framers, who knew that that language would incorporate the Constitution of Washington. So when you look at the language you just talked about, which was, it stated at that time, when it was first adopted, that the superior court shall have original jurisdiction over cases arising in equity in all cases at law involving the title and possession of a real estate, you understand that they didn't expect that a legislature would come along and take away that authority and make it non-judicial. It is, by the very nature of our Constitution, a subject of the Judicial Department to decide these issues.
And I would concur with you on that, and that's why I was so concerned as to come out here to interview you about these issues. I see there have been prior, what I'll call legislative affronts to the Constitution, and I noted in one of your briefs you cited to the Blanchard case, I believe, in Household Finance, and these were prior legislative attempts to undercut what I see to be, the basic tenets of the Constitution. Could you tell us about those cases?
Yeah, Blanchard is probably one of the closest cases. In Blanchard, the legislature had enacted a Labor Disputes Act, and it prohibited superior courts from issuing injunctions. And there had been a lot of labor distress, and a superior court issued an injunction against the Golden Brewery Company over in Spokane and told them not to interfere with these workers' rights. And what happened was the owners of the brewery, relying on the statute, violated the injunction. And so it went to the Supreme Court, and they argued, hey, the legislature took away these rights from the court. And the court said, no, we have 3 branches of government, and equity is within the authority of the judicial branch. Legislature has no right to have anything to do with that, and therefore you cannot rely on the legislature to protect you. You're within our jurisdiction.
Absolutely.
Now the other case.
Oh, please continue.
Okay, the other case is household finance, and it's the converse. In household finance, the legislature told the superior courts, we want you to review administrative licensing decisions and do it on a de novo basis, which means that they make the same decision based on the same evidence that the agency relied on. And the court said, hey, we can't take power we don't have. Just as we can't give up power we do have, we can't take power we don't have. And this is a familiar principle of American jurisprudence.